Okay, good morning. Today is Wednesday, April 9, 2025. Time now is 10:09. This meeting is called to order and held in accordance with Chapter 92 of the Hawaii Revised Statutes. This is the Hawaii Law Enforcement Standards Board. I believe, let's take roll. This meeting is held partially in person and via Zoom. Taking a roll call. Former Chair, Kauai Police Chief Todd Raybuck.
Present.
Attorney General Designee Matthew DeVonch.
Here.
Department of Law Enforcement Director Mike Lambert.
Here.
Honolulu Police Department Chief Joe Logan.
Here.
Maui Police Department Designee Assistant Chief Greg Okamoto.
Here.
Hawaii County Police Department Ben Moskowitz. Tax Director Designee Gary Yamashiroya.
Here.
Board of Land and Natural Resources Designee Docare Chief Jason Redula.
Present.
Shopo Selection Bobby Kavako. He is excused. He let me know he can't make it. Sherry Bird excused. She let me know she can't make it. Jared Redula.
I'm here.
And I think you have to say whether you're alone and in a
Yeah.
non-location.
I'm in my office alone. I am having issues with my camera this morning.
Thank you. Craig Tanaka.
Present and alone.
Harry Kubujiri.
Present and alone.
I think I'm present. So let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. So with a quorum of 11 members, this meeting is called to order. So Victor, can you read for the public if they want to provide testimony?
For internet access for testimony, to view the meeting and provide live oral testimony, please use the link that is on the notice of the meeting. You will be asked to enter your name. The board requests that you enter your full name, but you may enter a pseudonym if you prefer to remain anonymous. You will also be asked for an email address. You may fill in this field with any entry in an email format. Email name at yourmailname.com. Your microphone will be automatically muted. When the chairperson asks for public testimony, you may click the raise hand button found on your Zoom screen to indicate that you wish to testify to an item. The chairperson will individually enable each testifier to unmute their microphone. When recognized by the chairperson, please unmute your microphone before speaking and mute your microphone after you're finished speaking. If you do not have internet access, if you can enter, you can enter the meeting through your phone, audio only. Upon dialing the number that's included on the notice of the meeting, you will be prompted to enter the meeting ID listed. After entering the meeting ID, you will be asked to either enter your panelist number or wait to be admitted into the meeting. If you are a member of the public, you will not have a panelist number. So please wait until you're admitted to the meeting. When the chairperson asks for public testimony, you may indicate you want to testify by entering *9. After entering *9, a voice prompt will let you know that the host of the meeting has been notified. When recognized by the chairperson, you may unmute yourself by pressing *6 on your phone. A voice prompt will let you know that you are unmuted. Once you are finished speaking, please enter *6 again to mute yourself. Both internet and phone access when testifying, you will be asked to identify yourself and the organization, if any, that you represent. Each testifier will be limited to 3 minutes of testimony per agenda item.
Thank you, Victor. So to date, the board has not received any written public testimony. Brandon, is there anyone on Zoom that would like to present public testimony?
No.
Okay, let's move to agenda item number 3. There was a typo in the agenda. It says approval of board minutes for the September 30, 2024 meeting. Obviously, this is a typo. We approved the September 30, 2024 minutes at the March 6th meeting. This should be a March 6th meeting. However, because it is technically a different agenda item, I think the safer thing would be to defer this to the next meeting, so we don't get accused of misleading the public. So is there a motion to defer this to the deferred agenda item number 3 until the next meeting?
So
I'm-
moved.
Thank
second.
you. Thank you. Okay,
Second,
uh,
give me a
I
second.
did.
Oh, you did already?
you can third, I'll put you down.
Oh, thank you, appreciate it. I just want to be on the record.
Agenda item 4, is there any, again, I'll solicit any public testimony, Brandon, before we go into administrator's report? No, okay, I'll give Victor the floor for a few minutes so he can inform the board what he's been working
Good morning. Updates since our last meeting, March 6th. Stakeholder engagement. I was able to meet with Director Lambert along with our chairperson, Adrian Dakwa. On March 28th, we had a good discussion about training, Director Lambert's plans for the Department of Law Enforcement training and how those coincide with the board's objectives. As far as public engagement, I participated in a interview with the Civil Beat in March, which was printed on March 27th, along with Chairperson Dakwa. This, the focus of that interview was mainly HB 277 and the board's position. As far as administrative rulemaking, I'm continuing to review and revise a set of 9 rules. The chapter is 9 rules as it stands, and making sure that those rules coincide with everything that HRS 139 requires, and making sure that it conforms to everything that I've learned so far about the operation of each of our agencies. As far as the job task analysis process, I received word yesterday afternoon that there are probably 3 or 4 more administrative certifications that I need to obtain before I personally can administer the RFP for the job task analysis. And I'll get those done before the end of this week. And it looks like someone has been identified to sit down with me and assist me with entering that into the state's system, RFP system. And I hope to have that publicized and put out for bid as quickly as possible. Operational developments. We are continuing to identify some furniture so that we can furnish our office space and get established there as quickly as possible. That way the board will have a physical location and a physical office address to use in all of its business. So next steps, finalize the JTA process to get that published, the RFP published as quickly as possible. Continuing to work on the draft rules and get those in front of the board, and have the board deliberate how those rules are to be approved by the board and decide what form they will be. Are these going to be official rules? They go into the state, or are they going to be an internal policy and procedure manual for itself? Continuing stakeholder engagement. I hope to have a sit-down meeting with DLNR and SHOPO in the near future to get their input on everything that we're doing and the direction that we're heading. And other than that, I am always open and available for comment or input from any of the board members.
Discussion. I would add with regards to Victor's job task analysis, before it gets put out for the RFP, it will be circulated among the board members so we can all take a look at it, make sure nothing's missing or it's up to par. Regarding the cost of the RFP, the public should know there is no funding for the RFP. However, we are working with our friends within the Attorney General's Department to hopefully get that covered. Which leads me into my next comment that the budget for fiscal year 2026, it's too late, but that is on the horizon. Victor has been putting a proposed budget together for fiscal year 2027, since it's already April.
Chair.
Sir,
What, if any, funds have been requested for or authorized for the Law Enforcement Standards Board for fiscal year 26?
Zero.
Okay,
There
so,
were, I strike that, there were miscellaneous expenses, allotted, I think $3,000. It has been covering the cost of travel for board members, as well as I think the administrators travel to, visit different departments.
I would just repeat what we've talked about for the last 6 years, and that is that I think the goal of in the statutory requirement of Law Enforcement Standards Board is critical for our state and for our law enforcement partners. Unfortunately, since its inception, virtually since its inception, there's been no funding from the legislature for us to proceed and move forward. Let me re-say that. There has been limited funding from the legislature to support the requirements of this board. We did request and were provided funding for the administrator position and for a staff position. But as was just mentioned by the administrator, we continue to beg, plead, and borrow for this board to try to carry out its necessary requirements. And so I just hope that as the legislature is in session now, that with their authority, that they will begin to put their money where their mouth is and give us the funding we need to carry out what they've tasked us to do.
Thank you. Any follow-up comments? I would echo those sentiments. I think it speaks volumes that here we are in 2025, and we would like to thank our friends at the Campaign Spending Commission for letting us use their conference room and Wi-Fi. 7 years in, and we still don't have a physical location that is furnished, but hopefully that'll change before the end of the year. With regards to the draft administrative rules that Victor mentioned, though, that's also on the horizon for the next meeting, along with the job task analysis. So we are moving in the right direction with the limited resources we do have. Any further discussion? Craig, Harry, anything to add? Okay. Moving to item agenda 5, discussion of HB 277. I think at the time the board packet went out, it was in Senate Draft 1. Senate Draft 2 was not available. I brought physical copies and I sent it to board members, I think, last night. If anyone need a copy? Let me say this, that the legislature has made it clear that if the board does not act, they certainly will. They clearly perceive it, the current status quo, to be a problem. Noted in their latest committee report, dated April 4. It noted that your committee finds that police vehicle pursuits are highly dangerous, posing risks of serious injury or death to members of the public and law enforcement officers. However, existing law lacks clear standards for which pursuits are allowed and how officers are to engage in pursuits. This means that police receive little advanced guidance on how to conduct pursuits, but are nonetheless held responsible when pursuits go wrong.
Chair, can you repeat that line again, please?
Thank you. This means that police receive little advanced guidance on how to conduct pursuits, but are nonetheless held responsible when pursuits go wrong.
Not a true.
Well, yeah,
Yeah,
I would like to say for the record, that is absolutely a false statement. Each one of our police departments and law enforcement agencies have very thorough pursuit policies in place. And all of those pursuit policies are within the established guidelines set forward by CALEA, which is the premier law enforcement accreditation agency in the country. Even more so, throughout the years, specific events that have occurred have required police departments to modify their policies to be in line with federal guidelines in order to be and receive federal funding. And our police departments, as first I want to acknowledge and credit the comparative analysis done by the administrator. I think it's an excellent comparative analysis of not just our individual departments' policies, but also the standards and policies of other agencies and professional law enforcement organizations and their guidelines on pursuits, of which our county policies mirror and are in guidelines with. I agree with the legislature that pursuits are dangerous. There is not a member of this body that does not acknowledge the dangerous conditions that pursuits place our police officers and our community in. Each one of us has a policy, and I can say this because I've read it. Each one of us has a policy in place that limits and restricts policies to only those situations and scenarios in which it's necessary. We aren't haphazardly chasing people who are not a threat to the community. And if they are, those pursuits are terminated, reviewed, and corrective action is taken. I'm just going to say bluntly that this bill is in response to media attention to a pursuit that was justified, period. So I take exception to the fact that all this emphasis is placed on the police departments, creating a public image that is incorrect, that our agencies are not aware of the risks that are being taken and doing things and have policies and procedures in place that limit. Is there room for improvement? Absolutely. I think the administrator's analysis gives us a good spot to review and to consider on areas where maybe we can brush up our policies to even go a little bit further than they are. But to say that our police departments, that our police officers receive little advanced guidance is absolutely inaccurate.
Thank you, Chief.
So,
Go ahead.
I would like to echo that. I mean, our policy is much more stringent and based off of previous investigations, pursuit policy board meetings, and pursuit policy reviews of past pursuits that involve law enforcement agencies. If you remember when this law first came out last year, it was based off of the initial, off of a pursuit that was improper at best, illegal at most, and that was the reason for the pursuit policy bill at the state level to make a law. And it had no bearing on illegal or improper pursuits are not covered by policy, and they're way outside the policy, and those things are dealt with. The current law is stating exactly as was stated earlier, a complete false statement that our officers are not trained. They are. They're well trained. They understand the risks. They understand and they do risk assessments. They are tested on these kinds of things in the training. And so these are things that are extremely important, and it's disheartening that our legislature is making a statement that is not true about our law enforcement agencies and what they do.
This is Chief Okamoto.
I just, I concur with, the chiefs, you know, I mean, whenever there's a pursuit, the first thing to do is getting records for the officers. So, yeah, we are prepared, you know, we're educated, we're well versed in the pursuit policies. And the county should be able to, police themselves in that regard, as opposed to just putting like a real restrictive blanket, law out there for everybody, but I concur.
I concur with what the chiefs are saying. What's even more disheartening is that not only is it incorrect, but they're advancing a bill based on an incorrect statement. So I think it's improper to advance a bill on untrue information.
Yeah, and I want to thank Chief Logan for correcting or clarifying my earlier statement. Is the pursuit, one of the pursuits that I think was the impetus for this bill, as was laid out, was not within department policy. And as was mentioned, most likely, and could have been a criminal act, and that will be decided whenever that's decided. And no law and no policy is going to prevent people from not following law and policy. So making a bad law based upon a bad pursuit is a bad practice. I think that this board and the leadership and the members of this board are sincerely passionate about protecting our community. We do not want our police officers putting our community members at risk haphazardly, and those that follow the policies that are in place and the training they're provided do not do that. So I'll say again what I said last time. This bill is reckless. Although there have been some changes that have been put into it based upon, I think, some of the feedback, and I want to compliment and thank the chair and the administrator for going to the ledge and meeting with the lawmakers to try to have a conversation about this. So thank you very much. But I think this bill is reckless, and it actually will still put our communities at risk by legislating and making something so codified in law that it will actually jeopardize our community's safety more than the intended, which I will again say is well intended. I applaud the legislature for their intent, but I cannot accept what their outcome and their recommendations are.
And I think the redirection of the focus should be on the perpetrators who are the ones that are not abiding by or listening to our officers who are trying to make a traffic stop for whatever reason, a crime and or just a citation, but then taking off and putting the community in jeopardy. We should be enacting law that should be more restrictive on their part and more of a deterrence and more punishment to allow for a deterrent than we are trying to handcuff a police department, no pun intended, on a false statement that's made about a law and why we're trying to do it.
Right, so one of the recommendations that I have moving forward is that, to speak to Chief Logan's point, is that what I'll be recommending, and I'll be working on a draft, is that for next session is that for people that fail to stop, your vehicle can be impounded, because in a lot of these chases, and we're all out there before, we get frustrated, we're in the day-to-day, and when they run, we get more fixated on the fact that they won't be brought to justice. And sometimes that can skew our perception of the need to follow. So what that law would look like would be the officer tries to make a legal stop, the individual takes evasive action, the officer would have to initiate the pursuit and then at some safe point cancel it. And that would allow, what that indicates is that this person had every opportunity to stop, was evasive, therefore the vehicle would be grounds for impound. And what that'll do is, for example, let's just use that, Chief, if you're okay with YNI, right? Let's just say if the officers could have just done that, right? It's very possible there might have been a different outcome, right? If they could say, okay, he didn't stop, give me a number for failure to stop, and give me a number for impound. Because it's the motivation is that what we have to look at. And I think that if we have that type of legislation, we again support that the standards of training and rules fall on the LESB. I think that we can all win on this, because the reality is this, is that we got to be able to catch bad guys, and we have to have that latitude to have the officer determine that this chase needs to continue. But I think by having a reasonable, I guess, mechanism for accountability, I think is probably the best blend of reaction to this type of legislation.
Thank you, Director Lambert.
And just
What's that?
Chief, thanks,
Yeah,
Chief
just,
Moskowitz, thanks for joining us.
Thank you. Sorry, just finished my budget county council presentation. I would much rather have been here with you folks.
Chair, I'm looking at, I don't know, did you say this bill that you gave us is the most current version?
SD2.
SD2.
SD2? Okay, I have SD1, right? Can you, thank you. I, I have read the language and, to back down just a little bit from my passionate response earlier. I think the legislature has attempted to provide some guidance that is reasonable and considerable, but it also mirrors much of our existing language already. I think that as the administrator has already begun to do, I think that a comparative analysis of what's in the bill to our direct policies and looking for areas and opportunities where we can agree that the language in this bill does not constitute a risk to public safety. That we recommend coming up with a policy that consolidates the 4 counties and incorporates some of this language that may already be missing if it is so, for a recommended policy from the Standards Board for state and county law enforcement adoption. So I guess I would make a move or a motion for the board to do that.
Okay, lost in translation. Chief Graybuck making a motion to.
Well, I'll make a motion, then we can have discussion. So I would like to make a motion that the administrator expand on his current comparative analysis to review SD2 with the 4 county policies and whatever state policies that the departments may have, and incorporate language that may be in the bill. I haven't done the comparative analysis, so I apologize. But where language exists in SD2 that is necessary and applicable without risking public safety or police officer discretion, that be incorporated into a broad policy that all 4 counties and this board can deliberate on and make some decisions. That would be my recommendation.
Chair, before we move on to that, I think for sunshine reasons, we might not be able to take action on this particular agenda item in the form of a motion. But I would see this bill has a bad effective date on it. It will need to go to conference committee. So it's not gonna, we don't know if it's gonna become law yet, but just regardless, I think I would just ask Chair that for the next meeting, we put something on the agenda that the board can consider to direct Victor to take a particular course of action on this. And I agree, I have to agree with you, Chief, about that we should be doing that.
Okay, thank you for the clarification on the OIP. So I hope somebody wrote that down in case I'm not at the next board meeting and somebody else can make that motion, but.
Essentially, the motion is to have Victor look at.
Here, I'll rephrase my motion based upon the guidance from the Attorney General's office. I would make a motion that our next scheduled meeting, there be discussion and decision-making regarding a review of Senate Draft 2 and the county policies where language incorporated or added into this bill by the legislature be considered for incorporation into a statewide policy for discussion and action and decision-making. Is that better?
I think it is. I don't know if we actually need to do a motion to do that. I think we can just make an informal request to the chair right now that you would consider putting that on the agenda for next month.
So be
The
it.
next meeting.
Absolutely, I think this issue will take some time beyond just one meeting. and we're making good progress, so absolutely.
And as far as this, for discussion purposes, and maybe you could clarify this, is it possible to make this into a resolution?
For the next, on the agenda for the next.
No, requesting the legislature to make this bill into a
It's,
resolution.
Oh. What's the status of this bill right now? Is it gonna move to conference?
It will have to, because right now it has an effective date of the year 3000. And so in order to become law, it will need to go to the conference committee. Whether each house appoints conferees is another matter, I don't know. But it will have to at least go through that before it becomes law.
So I guess my question would be, would it be the intention of this board to write a letter to the conference committee asking them to either defer the matter for now or to provide them with suggested language on the bill for now, or consider if they would go to like a resolution instead of a bill, or
I don't think it's possible for them to do a resolution at this point because they already had to be introduced and I don't think there's any resolution that has the title that we would need. Or I don't think there's anything else. So I don't know if that's possible.
And for the record, I think the legislature is. It's pretty clear that the board's position has been. To appreciate the intent of HB 277, but we did oppose it, I think, at every committee. As it moved forward, and they've insisted on moving their version, their bill forward, so. I don't think our position could be any clearer. And if any member of the public or legislature is watching that, I think it's pretty clear that we're trying to do our job, basically. And we would hope that the bill stalls or that they would listen to us and defer the bill. At least for the time being, to see if the board could come up with something.
I think the past direction that we've given to the administrator on this bill gives him the latitude to submit conference comments that are along the lines of what he thinks is correct. He's here listening to this conversation.
so it looks like, at least from my perception, that we're faced with two choices right now, given the conference committee. Either to tell the conference committee in writing that the board would seek to defer the matter to get more time on this, or that we should provide them with language if this bill has any opportunity to become law in conference committee.
I think yes and no. I think they're waiting to see what the board can do. And if it's not up to snuff, they might still go ahead and move their bill forward. So I think the direction is clear that we've got to do something, otherwise they will.
And I want to acknowledge that, sometimes it takes the government and boards a kick in the pants to get things moving forward. And I want to give credit where credit is due. The legislature's given us a kick in the pants. And I know that, just to be clear, every person at this table is passionate about the intent of this bill. It is not that we do not want safe streets, and we do not believe in hazardous and dangerous pursuits by police officers at any cost. It's the process of legislating this in the manner it's trying to be legislated that we are in opposition of. We are not in opposition of making our community safer. And we're not in opposition of establishing and maintaining and holding people accountable to guidelines in doing pursuits. And so I just think that it's important to make clarity that I think I speak for everybody here based upon all of our conversations. We don't oppose this because we think police officers should be able to recklessly and haphazardly chase anybody and everybody they want. Our policies don't allow that already. But what's frightening about this language is I'm not a lawyer, but there's a lot of shalls and shall nots. And if that becomes a law and a police officer acting in good faith who has the information or limited information when they initiate the pursuit and after the fact gets Monday morning quarterbacked and new information comes to light, is it going to put our police officers at risk of some sort of civil or criminal penalties based upon this law? And that is a serious conversation that our legislature and we need to consider, because putting our police officers at risk of civil or criminal action based upon a law that has a lot of shalls and shall nots will be a chilling effect in the decision-making by our police officers who are doing their best they can in a dynamic and rapidly evolving situation to take action that may save a life.
Thank you, Chief. Any comments? Chief Moskowitz, anything to add?
No, here, Todd, I think you said it very well. And I think, that distinction that we're not opposed to, guidelines, but we already have guidelines. And so whether those guidelines are result in administrative actions and violations when they're violated, or, criminal repercussions, I think is a very dangerous road to travel. So I appreciate and, agree with exactly what Chief Raybuck just said.
Thank you. So just to move this forward, I think, let's get to the bottom of whether, how big of a problem, if it is a problem. We'd like to, people want to hear evidence, they want data. So to that point, I think Victor has already reached out to all of the agencies regarding existing data that the departments collect. My notes say, I think we got data from HPD, Maui. I think you're checking with Corp Counsel. All the other agencies, if you have not returned or submitted your pursuit data, please send that into Victor when you can.
So Chair, I'll apologize if you didn't get it. That means I didn't forward it. But in the matter of transparency, I can tell this board that last year we had one vehicle pursuit in 2024 on Kauai. That vehicle pursuit was outside our established policy. But the pursuit lasted for a very short time. I don't want to be quoted on that time, but it was less than a minute or so. And the officer actually terminated the pursuit himself upon seeing that the violator was potentially posing more risk than the reward of capture. And so it was voluntarily terminated by the officer, who in real time was able to, make that decision. So even though the initial reason for the pursuit was a traffic violation, he quickly recognized and disengaged. And so I think that's what the majority of all of our police officers do, and or our supervisors intervene to ensure is done. But I'll get you that information.
Thank you. As I'll take it a step further, as far as each agency's internal controls and reviews of pursuits. Chief Logan, can you speak to HPD's pursuit review board and what that entails?
So if there is a pursuit, once the pursuit is terminated, the investigation happens, there's a police a pursuit policy review board that gets together. It's made up of a certain number of people. They are there for a term of a year, and they do all the pursuits that happen. And by and large, there's really very few pursuits within a given year. And so they take a look at all the facts and circumstances involved, any citations, any arrests, any what the criminal offenses were, all the purposes of that. And then from that, they make a recommendation to the chief based on their findings and recommendations as to the outcome of the pursuit, whether it fell into standards. And not just the officer that's involved in the pursuit, it also looks at the supervisors, and it looks at the communications division and our police communications officers or dispatchers on their actions within that, to see if everybody's meeting or conforming to the policies. And if everything's good, then the recommendation is it's within parameters. If it's not and it's outside, then there may be corrective action taken to encourage people to not engage in future incorrect activity.
And correct me if I'm wrong, but the pursuit review board's recommendations can range from administrative discipline up to criminal prosecution.
Yes, can be.
Do all of the agencies have their own pursuit review board? I'm asking for the public, so I'll start with Maui. You guys have a review board?
We have a administrative review board, so it's not a pursuit review board per se, but if it's a quote unquote standard pursuit, it's usually adjudicated by the commander of the element involved in pursuit and then their assistant chief. If there is some question of some sort of administrative investigation or criminal investigation that results from the pursuit, then it'll go in front of the administrative review board. And then we also have an analyst who does a review of all the pursuits, and that's the report that's being currently reviewed by our corporation counsel for release. But yeah, that's Maui's policy.
Thank you. Kauai?
Yeah, as I mentioned earlier, fortunately, there's very few police pursuits on Kauai. We don't have an established pursuit board as HPD does because we have so few. We do have a process, though. Every pursuit is documented, and then it's reviewed by the Office of Professional Standards and our training section to ensure that the pursuit complied with policy. If it did not comply with policy and training, then it is, as in Maui, forwarded to the Administrative Review Board, and or the chief's office may order an internal investigation and or criminal investigation based upon the preliminary information that's received on the pursuit. The Administrative Review Board, after an investigation is completed, the Administrative Review Board would make recommendations to the Chief of Police regarding any action that may be taken. It would also include discipline.
And the department does keep stats of how many pursuits?
Yes. That's a CALIA standard, by the way. It is a standard for CALIA for us to document and identify how many pursuits and whether or not those pursuits were within policy.
Chief, you do the same thing for your doe care officers?
So for doe care, from the time that our vehicles have been designated as authorized emergency vehicles in the HRS, which was probably around 2009 or so till current, we have not had any pursuits that our officers have been involved in. That being said, we do have a policy. We don't have a pursuit review board. The pursuit would be reviewed by management. If there's any kind of evidence or inclination that administrative policies or criminal law may have been violated as a result of the pursuit, we would initiate the appropriate investigations.
DLE,
It mirrors Honolulu structure, so minus the composition of those reviews. The review board is mixed between sworn and civilian, but more its lawyers. It's our lawyers.
Chief Moskowitz, does Hawaii County have a pursuit review board?
We don't have a pursuit review board. We do have a pursuit review process, similar to what Kauai and Maui explained. Our process is basically paperwork, memorandum driven. The officers involved in a pursuit submit a memorandum explaining the circumstances and the other data points that we're going to collect. That works its way up through the chain of command. Is subject to various administrative oversight at different levels, including professional standards and training. And if there's something that's noticed outside of what our policy is, then that triggers an internal administrative investigation. And then the internal administrative investigation is overseen by an administrative review board as opposed to a pursuit review board.
Thank you.
Can I just add that speaking of review of pursuits, it's not just policy review. Invariably, the more significant pursuits are litigated. So there's a court who is reviewing the actions of the police department too, and the police officers. So that's another layer of review that pursuits are subject to. So we talk about statutory requirements. There's also, litigation. There's law created in litigation that helps guide policy as well.
Good point, Gary.
Thank you. One of the things that HB 277 requires is a lot of data collection. Not to beat a dead horse, but every agency on the board already has a practice that mandates that, correct? Like Chief mentioned, Chief Ribot mentioned, okay. What to do with that data, the bill says the data goes to the Attorney General. I'll ask our designee, First Deputy Matthew DeBonge, would the Department of the Attorney General have any objection to that data coming to the board instead?
No, I can say pretty confidently that we would not have any opposition to that.
And I think the standards board is probably the better place for that. In terms of talking about whether a statewide policy is what it's gonna look like, whether it's necessary, et cetera. I think that just makes things a little bit more efficient, and smoother.
There, in looking at the bill too, there's, some specific recommendations or requirements on the Law Enforcement Standards Board. Specifically regarding, the development of minimum requirements for both introductory and in-service training for law enforcement officers, supervisors, and it goes on. I think that language is,
Okay, wait, back up.
Yep.
Can you give us a page?
yeah, page 10. Page 10, section M,
Okay.
as in Mary.
Yep.
So, when it talks about, guidance and directives towards the Law Enforcement Standards Board, because I'm assuming that, the legislature's language, the board shall develop, is referring directly to the Law Enforcement Standards Board. If I'm incorrect, somebody please
I think you're correct.
correct me. I think that's language that is worthy, and I don't see a reason to oppose that type of directive in a legislative bill. I think that the legislature, within its purview and its right and its necessity, can and should direct the Law Enforcement Standards Board to look at minimum requirements. That is actually already in the law. So this is a duplicative command on the board, but it's more clear and directed. And so I don't take opposition with that. I think we should compare, confirm, and develop those policies where necessary. So I just wanted to point that out, that the language in this, there's good language in this bill. There's relevant language in this bill. And I think that this board and the law enforcement leaders on this board can use this as a guidance and as a recommendation for us to move forward and get something done. I think that if we take away the sensationalistic media reports of this pursuit or that pursuit, I think everybody on this board has made pretty clear today that pursuits are not occurring, willy-nilly across the state. A rush to incorporate a law based upon a sensationalist idea that cops are running rampant in the streets isn't true. And so I think the best approach is for us to take a measured approach that allows us to incorporate, consider, and move forward with language that actually does what it's intended, and not have the unintended consequences of placing our police officers at risk and our community at risk.
Thank you. Since you're on subsection M, the next page on page 11, subsection O, beginning July 1, lines 3 through 6. Beginning July 1, 2027, the Attorney General may investigate and, if warranted, bring a civil action against any law enforcement agency to obtain equitable or declaratory relief to enforce this section. Thoughts, comments?
I'm not a lawyer. And so I got to be honest, I'm assuming that would mean that the Attorney General's office can file a civil action against the chief of police and its police department for any violation of this law.
That's the way I read it.
The way that I read it.
Yeah,
yes.
I find that very interesting. And it goes back to what my earlier comment was, is that this type of legislation will significantly have a chilling effect. Look, the Supreme Court has ruled time and time again on this matter through civil action of what is a warranted police pursuit and what isn't. What is where civil responsibility lies on police officers and where it doesn't. And again, I go back, I'm not trying to be too brutal on our state legislators. I think their intent is valid. It's admirable, but their approach is flawed and has a chilling effect on law enforcement. Listen to the law enforcement experts in the room. This isn't about, protecting rogue cops. It's about protecting our community. So listen to our opinions. We're the experts. This is troubling that as a county, I might have to defend myself against the state based upon a flawed law that was enacted. Is that really what our taxpayers want? Is that really what we see justice? I don't know. That's troubling.
Just to tag on to what Chief Raybuck said, I think that, having worked on a lot of different legislative initiatives throughout the years with the legislators, I think the most successful ones are ones where, the experts are included in the conversation. If not before the administration of a bill, at least afterwards. And I don't know, maybe it's just because I'm all the way over here on the Big Island. Any of the other chiefs or directors, were any of you consulted by any legislators about the subject of this bill before it was introduced or since? I mean, to me, that's if we want to get to the right place, right, where the intent of the bill is honored, but we come up with something that's reasonable that will actually make a difference and help improve the community. To me, that's seems to have been an element that was missing, at least from this particular bill. Unless, like I said, maybe it's just because I'm over here in Hilo and out of sight, out of mind. But I don't know if any of the other chiefs were, or if any of the legislators, consulted with you folks either before the bill was introduced. So I guess that's more of a question than anything else.
No, to Ben's point, I think it was introduced last legislative session initially, and then I believe the four of us chiefs or whoever were available got together on a Zoom call with several legislators and their staffs over a slew of bills. I think the marijuana bills, legalization, I think this was one of those bills that originally had brought the wrong, it wasn't even a pursuit, it was improper at best, of officers who had no lights and sirens and no other pursuit. It was not a pursuit in the definition. And so we did have that conversation and the bill was deferred at that point, but then brought up in this session. And I would agree with you, nobody was asked about it. It was just all of a sudden, it came out as one of the dockets. But going to what Gary Yamashiro said earlier, according to letter O here on page 11, there's already legal and court, whether civil or criminal penalties and court jurisdictions over law enforcement officers in pursuits. And so we don't need another body on top of that and being dragged into court again over something that we're working on. We already have standards. We have our own internal investigations by our professional standards office, as well as the districts and division commanders that the officer may belong to, or the organization may belong to the civilian workforce. And so there's, it's just redundant and causing more issues and concerns to our officers who are going to engage in a pursuit to have this hanging over their head that they already have all these other rules and things they got to follow. And here's another one. Oh, I might get this outside agency or state agency coming after me if they think I did something wrong. And then what happens if we as a body, as the chief, I decide one way and say that it was all within parameters, but then the state comes back and says, well, no, we read it differently. And now we're going to get into this us against them kind of conflict. And it's just going to cause more problems than it's going to solve.
I think an analysis of the record will reveal that similar legislative attempts to address problematic events that have occurred in policing across the country. We look back at use of force issues, and state of Colorado enacted some very restrictive laws about, what police could and couldn't do. California and jurisdictions within California did the same. And as a result, law enforcement, police officers felt constrained. Colorado went as far as basically saying anybody could file a lawsuit against a police officer if they disagreed with their arrest, and those police officers were on the hook for defending themselves. This is a rabbit hole that well-intentioned people have very serious unintended consequences. I hate to continue to repeat myself, but it's got to get clear to people that this type of language, this language in O, will have a chilling effect on the beat officer that is out there who we empower and expect to make decisions that saves lives. And if they think that something they do is going to end them up in there already is great risk every day of civil action by the perpetrators, by the perpetrators' families, by community members, by prosecutors. And now we're going to go a step further, that if they're going to look at the pursuit documents and determine that, well, you know what, maybe we need to take civil action against the police department because we don't like what they did with this pursuit. It's gonna, I'm just saying, I'm not a fortune teller, but I've seen this 33 years. Some of us been in law enforcement for decades and decades. We have seen this repeated over and over again, what it does to policing. Again, there's a way to do this. It's not by setting a law. Give us the guidance. Allow us the autonomy and the responsibility you've given us to do the right thing, and we'll do the right thing.
So for full transparency, I was able to get an audience after the most recent hearing. So for this edit, and they didn't listen to all my recommendations, but I did ask for them to strike out the specific crimes under the pretense that anytime a new law is added, you would have to jump back into this to see if that's an offense. So again, I was able to get an audience for the group transparency, just for the sake of it. So couldn't get everything I asked for, and I did within that meeting express my intent to come up with the impound law for next year. So that staffer was willing to entertain that conversation. So just for everyone's.
That was prior to.
That was
Senate Draft
after, that was prior to Senate.
Well, and as we all know, with a conference draft can come out and have anything that was in any of the previous drafts or something else completely, that wasn't in any of the conference drafts. So while it might not be in the current SD2 version, any and all of what we've discussed could be re-included in a conference draft.
Also, one more thing I'd like to point out on page 9, subsection 4 of I, it talks about each agency shall make publicly available all of its policies, including procedures, general orders, special orders, regulations, and guidance related to vehicular pursuits. I'd like to hear positions from each of the departments.
Well, PD, we already do it. It's on our website.
Is it redacted or unredacted?
My understanding is unredacted, but it's public. I'll go check it out right now. If there's something redacted, it's an operational thing, but my belief is unredacted. I'll confirm it for you in 30 seconds.
HPD, ours is on our website. It's available to the public. It's unredacted.
Kauai Police Department's not on the website, and it's not because of a lack of transparency. It's a lack of IT support and resources to post all of our policies up there. So I'm not opposed to placing it on there.
Same with DL, you have to check. It may be, and if it isn't, I have no opposition.
For DLNR, ours is not on our website. For purposes of this meeting and the discussion, when we were asked to provide the policy, I did redact certain parts of it for operational security purposes, because it does speak to when officers would engage in a pursuit and what kind of actions they would take. And I just, for operational security, we did not want to divulge that publicly. so that the bad guys would know what to expect.
Thank you.
Maui's is not on the website, but we I gave you a copy of our policy unredacted, so we're not opposed to, posting it unredacted.
With regards to the issue of operational security, does that, obviously, if some departments are not opposed to it, but it is a legitimate concern. Can you tell us give me an idea of your guys' positions on whether we should object or include language like in subsection? Because we're trying, like Chief Raybuck said, this bill is well-intentioned and there is some good language or some bad language, but there's also some good language, and I'd like some feedback in terms of subsection 4, making it publicly available. Office of Information Practices weighed in, saying it could affect operational security. Can we get a discussion on whether to agree, edit, or oppose this language?
I think it also should be added that the exceptions in the 92F UIPA laws are allowed.
Hmm.
So redaction is allowed as long as it fits within a 92F section.
So essentially, if your policy includes tactical guidance, then that can be removed.
So in other words, no objection. What I'm hearing is no objection to paragraph 4, I4.
It allows us to redact it, operational security information based on 92.
The specific language in 92F is it
Frustrates the legitimate purpose of government.
Function.
Yeah.
Better term.
Yep, no objection from Hawaii County.
Having said that, because your policies are already publicly available, has that been a workaround? Or do you still have upset with what's published publicly?
All of our policies are online. There are some that are redacted based on the frustration part of 92F.
Okay.
Where it's tactical in nature and we don't want to provide certain information to the public. They don't have a right to know all of it. They need to know what the general policy says. Yeah.
I think the conversations like this and media events make it pretty clear to anybody who's paying attention what the police can pursue and what they won't.
Okay, so to summarize, I want to go back to what Chief Raybuck said, that the direction that this discussion is going in, we're gonna have our administrator take a look at county policies, the language in HB 277, and see what we can incorporate and hopefully come up with something synergistic. Is that safe to say? Okay. See nods of heads. Any further discussion? Craig, Harry, Jared?
Chair. Can you hear me?
Who's that? Jared?
Craig.
Craig, sir.
Hey, I appreciate all of the conversation. Chief Logan spoke about certain things that really I had marked on the draft as well. And while I do believe that there are good intentions, this focuses, I think, on trying to guide law enforcement in things that they already have established policies for. I mean, each county has already established policies. Each county has established administrative processes and legal processes if and when there's a situation that needs to be addressed. And I would agree with what Chief Raybuck says is, and all of the chiefs are saying, is that we have a legislative body that while seem to have a good intent, good heart with it, are focusing on things that are outside, I think, of their professional capability, which is why we have chiefs of police, we have different counties and different police departments. But each one has established policies as it is already. And I think Chief Okamoto had mentioned about the process of impoundment. Um, I just find it very frustrating that there seems to be that handcuffing of the people who are trying to save and provide safety for our residents, for our people, when the people who are actually causing these situations for a vehicular pursuit or any type of situation involving law enforcement are not held accountable for it. So, and all of the spotlight and all of the negativity falls upon the people in the room to justify what they're called on to do in the first place. And so I think my thing is, what is it that what's happening right after this meeting? Where are we going with this? What can we and should we do? Because I do believe that, yes, this, if it does pass in its current verbiage and language, is quite concerning. So I felt, I mean, I'm not that law enforcement person, but I do highly respect that. But I also feel that the people who are causing the initial situations that for crime and pursuits are not held accountable and are putting the other people who are protecting us in the spotlight and really, really strapping them down.
Well said.
And
Anyone else? Harry, you want to add anything?
No, I think, I want to try avoid redundancy. I think all the chiefs and everyone there at the table, expressed exactly what I was thinking, about this, bill in the first place. So nothing new to add to that.
Thank you. Chief Padula.
I think I agree with what Craig said towards the end of his statement. It's unclear to me at this point, what the board intends to do with the current bill that is apparently being referred to conference committee. I go back to my earlier statement. I think either we're gonna be asking for more time to deal with this as a board, or we're gonna have to offer up some recommendations immediately to the conference committee for their consideration. In the event this bill gets moved towards becoming a law. So I think we kind of should figure that out, because I'm thinking that with the current timeline left in the legislature, we're pressed for time already.
Yes, conference committee starts the end of this week and next week, I believe, or next week.
Yeah, so it's gonna start next week.
Yeah, I appreciate that. My opinion would be that we ask for more time. I don't think we have seen, and I do want to applaud you, Mike, and I want to thank the members of the ledge that you met with that did modify some of the language in the bill after your conversation with them. So I do appreciate that. But given the timeline of this and the seriousness of the matter, I would think it would be best for this board to request time for us to do the right thing and for them to delay enacting a law that might have the consequences we've talked about already ad nauseam.
So for the parts that didn't get taken in my meeting, it was to actually just strike out all of the granular language and just have it where the LESB would have to present a report upon some type of effective date. But I guess, maybe beggars can't be choosy, get what you can get. So I was able to push it a little forward, but I think if it was the strength of all chiefs and directors, that may have had a different outcome. But I know at this level, sometimes it's legislative liaisons that will create these discussions, but when it's this hard hitting, like for example, Chief Logan came out in person. So I think that when it does for this group, for LESB related issues, if it does hit that chord, I think that it should be, if possible, direct leadership requesting these meetings. And I can say from dealing with elected officials, when it's your chief or your director, if there's a much different response than to say my lieutenant is gonna come talk. So just in moving with all bills, but particularly this bills, just a recommendation to them. They know how serious it is, depending on who's showing up.
If they listen to these meetings, they'll know exactly where we all stand and how serious it is. Some of us don't have the manpower and resources to fly over to Honolulu every time to try to convene with a different bunch of meetings. That's why I really appreciate those of you that are here on Oahu, that you have the ability to do that. But, you know,
What I will offer then is, this session is pretty much, we're rounding third base, but what I will offer the outer county chiefs is that, because I do have the flexibility to fly in and out, is that next session, perhaps I would come out, and if you guys would allow me to speak on your behalf in these meetings, in other words, we've discussed it individually, and I can go ahead and express in those meetings what the discussions were on the outer counties. Of course, Chief Logan is here on island, and his assistant chiefs would probably be appropriate as well at that level, but at least it should be a chief level, not to say the chief, but a chief. And I would offer that to the outer islands as a opportunity to segue.
so, thank you. Chair,
I would encourage, what Director Lambert said, if you have the time and resources to meet with the legislators, please do that. I would also encourage, all of the agencies to get us the data for vehicular pursuits within the last 5 years. Can we do that within 2-3 weeks?
Yeah.
Let's say 2 weeks, get us what we need. I think that will help, present more of a compelling argument that maybe we don't need to rush to judgment on this bill. And at the same time, the third prong is to have Victor kind of see if we can synthesize and put together a draft that combines some of the language we like, but that we're not opposed to in HB 277, but is also consistent with all of our agencies' policies.
Chair, is your intent to use the data provided by the agencies in testimony, conference comments for this bill, or for?
If we can get it,
I think the only reason I say that is because I think 2 weeks might be too long. They could go to conference on this bill next week and make a decision about it.
it's a great point, so.
Basically,
I think we can give you, I think all of us already have that data already compiled, and I'm trying to search my inbox because I actually think I have the document you're asking for, but my phone doesn't work. So I think we can probably all get you that by the end of the week.
End of the week?
Does anybody have any problem with that, Ben?
No, my understanding, and I checked by email during this meeting, my understanding is that we sent it last week. So I sent Victor an email just now. If you don't have it, shoot me the email and I'll get you the PDF. I think ours is either en route or it should be in your inbox somewhere.
I think your major was going to send it. I asked them just double check with Corp Counsel to make sure it's okay for public dissemination purposes. And then I
Yep,
think.
I remember signing the memo, the cover memo to send it last week, so. And I've checked
Okay.
and he said it was sent. So if you don't have it, Victor, email me and I'll get it to you today.
So end of the week. Pursuit data for the last 5 years from all the agencies. Yeah. Okay.
Can I just add that if you're going to talk to other board members, that you consult with the AGs regarding the
Yes.
sunshine?
sure. That's why I said individually.
Yeah.
That is all. Please talk to us.
Yeah.
It depends.
Yeah.
Okay.
It's under the purview of the board. If
Yes.
you're doing it as a.
As a DLE director
Yeah,
and
that's the difference.
reaching out to chiefs in their chief capacity, as not a board capacity. Yeah, that might be better.
Okay, I think we've made a lot of progress today. I don't have anything further at this time. I'd like to see the data we get. And see if Victor can come up with something.
Chair, did we make a decision on what we're gonna do regarding Jason's the other issue of where the board is gonna go? Are we gonna request them to postpone? Are we gonna wait till you get the information? Are we gonna ask for redacted or revised language? What are we're gonna grant the administrator the authority to,
I think the administrator has the authority to do that.
we already did that, so.
Um,
Do we wanna, is it right to make that decision and let them know where we stand based upon our conversation today on this bill?
I would say so. I think that's what Victor's trying to been working on since the get-go. I don't know if we need to make a formal ask. I think our position's been very clear. But the one-on-one behind the scenes might be more effective, like Director Lambert said. If we have something in hand, I think that will go a lot farther to convince them that this bill is unnecessary.
But, getting back to Chief Padula's point, are we going to submit a letter to the conference committee? Or are we going to request deferral, or which is
What I-
basically asking for more?
What I will share, from my discussion, the temperature is that they want something to pass. So my recommendation would be to provide language so that that can happen and it doesn't distract what we need to do.
Well, then I think that unfortunately, you've met with them, you've shared your concerns, and they didn't redact the language, and I don't know that they will
Well, like I
redact.
said, I'm one of 6, right?
Yeah,
So,
so I don't. Or is it your feeling that the collective law enforcement?
so
standards-
I don't think they're against, okay, so the language, the sense was they wanna. They're open to discussion, but I was only one of 6 voices, right? So you got 4 county chiefs, you got DLNR and you got me.
Yeah,
So-
but this group is the Law Enforcement Standards Board. It's comprised of all law enforcement entities. So I get that they may want FaceTime individually with each one of us, and maybe that would be beneficial. But we are all speaking collectively as a
We
group.
are, and then, like I said, that's what that note, that's what that recommendation would convey, is all 6 having a cohesive vision for this bill.
What,
My
what
point-
6 are you talking about?
Where you got 4 county chiefs, director of law enforcement and DLNR.
At a minimum, if the board has no objection, I would have no problem writing a letter on behalf of the board to conference committee stating the board's position.
And I agree with Chief Lambert's, our Director Lambert's, suggestion that it be a report, purely a report, and that there'd be no procedural aspect to it, you know, getting down to, I can't remember how you,
Granular.
issue, the granular portions, directing people, directing officers how to conduct. And just recommending that the board maybe provide a report as to their, for the 2026 legislative session, how, you know, what they've accomplished in reaching the statewide policy.
And guidelines.
I'm speaking for myself.
Yeah, I just want to share the temperature for urgency is my point, was my point.
I appreciate it, and I understand there's an urgency, but my interpretation of what you've said and what I've been seeing is that the urgency is based upon what they want to see and not what they want to hear from us.
No, I think that they would love to hear from us.
Well, we've been
Um,
saying it at these meetings. I'm not trying to be,
Yeah, but I mean, not to debate with you, chief, it's just that expecting them to sit here and watch us while we speak, they have their own business, so I think that to assume that they even watch this is bold.
Okay,
So I think that, yeah,
I don't disagree with you.
so I think
So-
that sending this would be more direct.
So is it then, am I understanding what you're saying? Is it the Law Enforcement Standards Board today and all of us adding our signatures to it? That we don't support this sections of the bill and we ask that you,
And there's a cohesive voice via signature that this is what we've all agreed upon.
yeah.
Via the law enforcement side.
So the question I have then, do we need to go through this page by page and cross out the sections that we don't agree with?
Well, I don't like the granular parts of it, so I would just strike out all of that, and then my recommendation during my meeting was that allowing the LESB to, they have to create those granular steps by an effective date. And then the reason why the recommendation that I had is that as things change, you don't have to re-legislate it. The LESB can reset that standard as needed.
So in the language that's here, and I'm not trying to belabor the point, I'm trying to understand and get
Sure.
clarification, that's all.
Sure. And again, that was just my personal position.
Yeah.
Not speak, and I didn't want to speak for anyone else.
No, I appreciate it. So is there language in this bill that you think we should carve out and say, this is the extent of what we want to see you move forward with?
Yeah, there are portions that I just felt I was indifferent to, like, for example, posting and that kind of stuff. I did, the part that you brought up with O, I was concerned, but if it was set by the LESB, the standard set by the LESB, in which all of us have a seat at, then I felt it was kind of moot. Because in other words, where we would be agreeing to this process, what's in there. So it's kind of one of those where, you know, it's like telling me that we all agree we're not gonna steal, right? So it's like, okay, right, you know what I mean? Because we all set the standards, it's, you get what I mean? So, because always moot, because we all dictate the standard, but you're right, but because I didn't get my way, because these standards exist with O, that is concerning.
When you say O,
Would strike out. Yeah,
O is
page
the
11.
civil action.
Correct.
Is that what you're talking about?
Yeah,
Okay.
yeah, because in what I was recommending, it would be moot, always moot if the standards are set by the LASB, which is set by us, right, as a cohesive group. But you're right, because I didn't get what I needed in my entirety, yeah, now always concerning, sure.
And I would suggest that our primary is deferral, and that there's a backup.
I agree 100%. I think, I go back to what we've said, and I've said multiple times already today. The legislature has already empowered and required us to act. And so we are trying to do that. You've made it a priority at the ledge for this to be addressed. We are making it a priority on the board to address it. Now give us the time and enable us the authority to take action that you've asked us to do and to do it right. So I would say the Law Enforcement Standards Board, with all of our signatures, request a deferral so that we can take up the matter and consult with them, and they can consult with us, and we can have the time to meet face to face where necessary to craft language that doesn't pose a risk.
And I think I like the dual option of saying however, right, and then having that. In other words, however, that's off the table, then please consider these points.
And I think, keep in mind, the legislature can defer this and bring it back next session.
Yeah, that's I am.
Right? So if we have some kind of draft that we can show, whether it's next month, by the end of the year, something, I think that would go a long way. And again, if it's supported by data, that might go a long way in terms of convincing conference committees that they're on the right track.
Is it correct to state that because the session is the same, it's just a 1-year difference with the same legislators, that the bill could be revived at the conference stage? They could just conference and pass something that would pass through both chambers. They don't have to go back and rehear each of these things at committees, right?
No, I believe it stays, it can come back in conference.
Right, so they could just go next year when the legislature convenes, they could go straight to conference, do whatever they're gonna do in final form and pass it out.
No, the legislature could say, we gave the Law Enforcement Standards Board pretty much a year to give us something. Because the board either failed to do so, or we don't like what the board put out. Here's HB 277 in conference, right?
Or they could take what we've given them and amend 277 to something else, but they would, my point is they could go straight to conference when the legislature convenes again. They wouldn't have to go back through individual bills and crossing over. They could go straight to conference, out of conference, back to each chamber, and they would be done.
Yep.
Okay.
Okay. Okay. To summarize, the board will submit a letter asking the legislature to defer this bill. That let them know that we are working on it, that we should have some kind of data to back up what we're saying. And that's due by the end of the week. The data is due by the end of the week. We'll get the letter in front of the conference when it pops up. Is there agreement on that? That's the course of action for following today's meeting?
Yes.
Yeah.
In addition, can I suggest not even waiting for the conference to come up, but approaching the committee chairs of each committee that heard it in the House and Senate with that data proactively? Because that's,
Absolutely.
and the discussion with the leadership in the House and the Senate is what's gonna decide or not decide whether conferees even get attached. And even if, you know, some political thing happens between now and then and nothing happens, I think we should still move forward with our solution, you know, as a board, regardless of what happens at the legislature. So maybe approaching them proactively with that data. Look, here's the data we've been able to come up with to whether it's the president of the Senate, the Speaker of the House, or the chair of those individual committees that heard it, might even prevent them from having to have a conference committee scheduled in the first place.
Sure, that's a great idea. The sooner I get the data, the sooner we can start reaching out.
Yeah, thank
Okay. Brendan, again, is there anyone from the public online? Nope. Okay, I believe that covers all of the items on the agenda. Is there a motion to adjourn?
Motion.
Be- Before we hear that motion, and vote on it, I'd like to take the time to recognize and thank Kauai Police Chief Todd Raybuck for his leadership on this board throughout, pretty much from its inception. And to articulate that better, I'll turn it over to Matt.
Sure, Chief Raybuck, I think, speaking on behalf of everybody here, I think we all feel the same way. Your leadership on this board, it's not been easy. As you said earlier in the meeting, this board has not been funded appropriately from the very beginning. It was just recently that we were able to get some funding to hire Victor and another support staff person. But you've been there throughout all of this, through thick and thin. You've really guided this board in the right direction. And I think you've set us up for success. And for that, we thank you.
I just want to thank each and every one of you. We've come a long way as a board. 6 years ago, when I came on this board, there was a lot of opposition by members of the board to this board's, even, you know, to the existence of this board. And I want to applaud and appreciate each and every one of you, because we recognize and we all appreciate the important work that this board needs to do. Policing is a noble profession, and it is a profession that is filled with men and women that sacrifice their lives and time away from their family every day for our community, and some of them pay and have paid the ultimate price. And I think there's no more important work to be done than law enforcement leaders and state legislators to make sure that our officers have the tools and resources and guidance that is necessary for them to perform their jobs and go home every night, and so that the people that we contact go home every night to their families too. It's been an honor and at times challenging to be on this law enforcement standards board, but the relationships, being able to see the competence, the passion, and the leadership of the law enforcement professionals that make up this board have been an honor for me to be part of, and I'm humbled to be within this group. And I wish you all the best of luck. And I thank you for allowing me to be part of this group.
Okay, the motion to adjourn was made by Chief Raybuck, seconded by Gary. Get me the data and we will be in touch for the next meeting. Meeting's adjourned. Thank you.